I'm glad you could join me today. I want to talk to you about the typical court process for a mischief charge under the Criminal Code of Canada. So what are the general steps once you've been charged with mischief that happen in court, out of court? What are the timelines if the charge is withdrawn, you plead guilty or go to trial? These are the things that clients want to know. They want to know what's going to happen with their case and what to expect. We go over this very carefully with them at our initial meetings and all throughout. We need to keep reminding them of the court process we go out. It's important to be informed. So what happens? Well, let's say I'm charged today with mischief by the police. I broke something in my home. I was mad at my spouse and broke some dishes that we jointly own. So you're going to be charged with mischief, or I damaged a car intentionally, whatever I did. You're going to be charged with mischief by the police, and if you have no prior criminal record, they're going to release you. You're not going to probably have to have a bail hearing, and they're going to release you on a promise to appear or an officer in charge undertaking likely, and they're going to give you a court date. It's hard to say, it depends on the county, but typically we'll say 3 to 6 weeks down the road. So you hire a lawyer, and what that lawyer does is they have you sign a designation. It's just a document that gets filed with the court where that lawyer is there to represent you. The lawyer will order the police reports. It's called the disclosure. All the witness statements, video statements, police notes, you name it. There's going to be an extensive package of documents that are provided to defense counsel eventually. And those documents, really, the defense counsel needs to read them carefully, review them, analyze them to figure out, well, what are the strengths and weaknesses of the Crown case? What should we do with this case? Should the client consider pleading guilty? Can we win it? Is there defense? You name it, it's all in those documents. Now, the Crown's attorney's offices in the province, they strive to get us those documents before the first court appearance, but it doesn't always happen, believe me. In fact, it seems to be happening less and less over the years. And we often get those documents after the first appearance. So what do I do as a lawyer? I attend the first appearance for you in court. That designation's been filed. So now our court system during COVID, and probably after COVID too, and I'll do it later update when we get out of COVID, the first court date automatically goes over 12 weeks. So that's automatic now. And as a lawyer, we're expected to complete as many steps as possible in that 12 weeks to move your file along. So the first step, of course, is reviewing and analyzing the disclosure, having one or more meetings with you as a client where we review it, receive your version of events, and figure out, again, the strengths and weaknesses of the case. Is this defendable? Should we resolve it? Can we get diversion? Will the Crown withdraw it? Can I get a peace bond? And as a lawyer, I'm thinking, what's the Crown likely to offer here? Should this head to trial because there's such a weak case? Should it be withdrawn? I know the strategy after meeting with the client, after reviewing all this stuff. So that's crucial. That's a crucial step, reviewing this. So we'll have one or more meetings. I'll probably get you to write out your version of events, get your personal history and background if we're negotiating a deal, because your background's important, that you're a good prior person, a good prior character. Now I'm ready to meet with the Crown. So that meeting will likely take place between the first and second court appearance. It's called a Crown Pretrial. At that meeting, with your instructions, I am having a fulsome discussion of every aspect of that file with the Crown attorney. I'm trying to convince, of course, the Crown to withdraw the charge in a right case or go on diversion, where you can get a peace bond perhaps and get this withdrawn if it's a more minor case. We're going to see what the Crown's offering. We need to know. Maybe they're offering a conditional discharge, but, wonderful offer. It avoids a record, except I think I can win this case, so off to trial we go. We have that discussion. I report back to you. I report back to all the issues under discussion. The Crown and I might need further discussions, by the way. The Crown might say, for example, look, if your client gets upfront counseling, I can agree to diversion, withdraw the charge. Maybe a great deal if you're not innocent. You might not want to do that if we got a slam dunk case, but slam dunks are rare. There's risk always in heading to trial in Ontario. So you provide me with your instructions. You say, Mike, they're not offering a deal. You've told me I got a decent chance of winning. Off to trial we go. Or Mike, that's great. I'm getting a peace bond. I'll do the counseling. Let's do it. And we'll eventually take this deal. So if we decide to go to trial, The next step in the file is to have what's called a judicial pretrial, which is simply a meeting with a judge who is not the trial judge, where the Crown and I sit down and review all aspects of the file with the trial judge. How many witnesses are going to be called, the names of the Crown witnesses, what the legal issues, what the factual issues are. The judge might rhyme in or chime in about the strengths and weaknesses of the case. Maybe if they're a more interventionist judge, they might convince the Crown to offer a deal. It's kind of our last hope to get a deal. And that's a required step. We might need more than one judicial pretrial. Usually one's enough for a Mischief because it's not a complex case. After we've had the judicial pretrial, we are in a position to set a trial date. Now, where are we in the process? Well, we've had our first appearance. Haven't had our second appearance yet, but we've already had a judicial pretrial. So at the second appearance, we might be in a position to set a trial date. That's only 3 months from, that's 12 weeks from your first appearance. Or we might not. We might not have full disclosure at this point. We often don't get full disclosure with the initial package. So what's a timeline then? So we might need, sometimes we need more than the second appearance. It might go to a third appearance, sometimes even a fourth. It really depends. Every case is different. But we're trying to move the file along as quickly as possible, but we're a little bit at the mercy of the Crown, whether they give us full disclosure. We're a little bit at the mercy of how many criminal pretrials we need. Crown pretrials we need, which is the meeting. And the judge might want another judicial pretrial, or you're doing counseling as well at this point. So now, okay, so let's say it goes to a third appearance. We're now, we had a first appearance, we're 12 weeks in, another appearance 3 weeks down. We're 15 weeks in at this point. We're almost 4 months in. Now we're net ready to set a trial date because we've completed all the necessary steps leading up to all the prerequisites, that is, to setting a trial date. So we organize a trial date with the trial coordinator. We've estimated 1 full day of trial time. That's set down the road at the next court appearance. And now, when's that trial going to take place? Well, it really depends on the county. I can tell you this. In some counties, we might be able to get a trial date 6-7 months after the first appearance, but that's really pushing it. Believe me, in Ontario, that's a rarity. In others, it might be 9 to 12 in less busy counties, and others 12 to 15. I've even seen trial dates offered up to 18 months. So in Ontario and Canada, in fact, you're expected to complete your trial. 18 months is the limit, really, after the date of arrest, or you might have a delay issue. I covered that in another video. You might be able to get your charge stayed, depending on the factors. So that's if the matter heads to trial, okay? So what are the outside parameters? 6 months is almost too early, but I'll say 6 to 15 months, even 18 months in some counties, but more likely in the 9 to 15 range, depending on the county, after your date of arrest, okay? Now, if you decide to plead guilty or you've got a great deal, that court dates can be moved forward. If you decide to plead guilty and we had a first appearance and went over to second appearance, that second appearance can be moved forward. Hey, they're offering a conditional discharge, no record, or they're offering a peace bond. So don't worry about the court dates. The remand court system, it's a real anachronism, old, outdated, it's useless, and I hate to say that. You can watch some videos I've done on that, including some of my critiques about COVID and other videos I've done on critiquing the court system. Think of it this way. It's just a reporting mechanism where the Crown and I appear before a justice of peace and say, look, the justice of peace is asking, what the heck's going on in the file? Your worship, we've had a Crown pretrial, we just need a judicial pretrial. That can be done by email. I don't know why we have our system. Don't worry about the remands. They can be moved forward, they can move backward. Don't worry about how long matters go over, because the real steps on the file are taking place between the remands in my office, in a judge's office, or in the Crown Attorney's office with our meetings, okay? So, in other words, if the matter's resolved, that resolution could take place, even within a month or less of the first appearance, frankly, if we can get organized and we get the disclosure. So resolutions, you're looking at more of a 1 to 5 to 6 month timeline, anywhere in that region, especially if you have to do counseling. But by the way, if they'll withdraw it, if you do counseling, counseling is going to take time. So those are the timelines. Those are the general steps in a mischief charge. I encourage you to watch my videos on all of these topics because I cover first appearances, I cover the disclosure process, I break it down, I cover judicial pretrials, crown pretrials, and what happens at a trial in a whole host of videos. But this is just a general overview, and I hope this helps you understand how your mischief charge is going to proceed. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.